innovation leader by any means necessary, including stealing American intellectual property. But the bigger concern is that China may soon out-innovate us, not just imitate us. We need to recognize that possibility and adjust our strategy. The U.S. is still ahead, but China is closing the gap. China uses many tactics, including counterfeiting, espionage, fraudulent filings, and flooding the patent system to gain an edge. We must stay alert and protect our innovation ecosystem. Strong, reliable IP rights are vital. They drive investment, support millions of jobs, and fuel nearly half of our GDP. There are three areas that urgently need attention. Patent eligibility law. It's broken. The courts have created confusion and innovations like diagnostics that are suffering. That's why I've introduced the Patent Eligibility Restoration Act, or PARA. The Patent Trial and Appeal Board reform is also important. It was created with good intentions, the PTAB, but now we see its flaws and it's time to fix them. And we also have to win the AI race. We can't afford to fall behind China, but we must protect what has made us a leader, and that's strong IP laws. So we need a balance between the two. We can't overreact. We still want to be the most preferred haven for innovation. AI is a part of our future. It's not a matter of whether, it's a matter of when it becomes a part of everybody's daily lives. And we're here to make sure that we create policy that's sustainable, that makes the United States one of the most attractive jurisdictions for innovation going forward. I'm going to submit more comprehensive remarks for the record, but for now I'm going to turn it over to Ranking Member Schiff. Welcome.
Thank you, Mr. Chairman, for convening the first Intellectual Property Subcommittee hearing of the term. I'm really honored to be the ranking member on the subcommittee and look forward to continuing the strong bipartisan tradition that you and Senator Coons have maintained for many years now. I want to thank all the witnesses for being here. I look forward to your testimony. And Mr. Muller, particularly interested in your experience. I remember years ago, one of my constituents coming to me. He was the manufacturer of high-end speaker equipment that's used in rock concerts. The brand was extremely valuable. He sought a broker to manufacture the brand in China. They started manufacturing in China. He was not pleased with the quality of the manufacturer, so he went to the broker to find a different manufacturer in China. About a year later, he found out that the first manufacturer continued to make his speaker equipment and market under his company name, and unbeknownst to him, had gone to the trademark office in China and secured the trademark for his own brand. And it sounds like you've had a similar experience. I'm also eager to hear and to highlight the innovative and unbounded IP that's come out of the United States, and I'm really proud of, obviously, what's come out of California, whether it's the University of California system, which consistently leads universities in the number of patents granted, or the Silicon Valley, home to some of the most incredible tech innovation. I'm proud to represent California in the Senate and to serve on this committee. The U.S. is home to some of the strongest intellectual property systems in the world, in large part because of the ingenuity and dedication of our inventors, but it's also due to the strength of our IP laws, which aim to protect American innovation from nefarious actors and to put money back in the pockets of our inventors and creators. The Patent and Trademark Office, the U.S. Copyright Office, both play crucial roles in reinforcing those laws and protecting American IP, and it's essential that they remain strong and independent. I am concerned, I must say, with the removal of the Registrar of Copyright, Shira Perlmutter, on Saturday, which does threaten, I think, to undermine the independence of that office. And I've written to the president to register my concern over this, as well as the legality of doing so. But in terms of the reason we're here today, in order for the U.S. to compete globally, it's critical American innovators and intellectual property are protected at home and abroad. And I know that the chairman, myself, and our colleagues agree that we need to be doing everything in our power to maintain the U.S. position as the worldwide leader in innovation. Business owners from California to North Carolina, from Tennessee to Hawaii, and everywhere in between should have the confidence that their patents, copyrights, and trademarks are not being infringed by copycat companies overseas. American consumers should have confidence when they buy a product advertised as coming from an American company that they are getting the real deal, not a counterfeit version from overseas that does not comply with the same safety or manufacturing standards as required in the U.S. America's leading tech companies must be confident they can innovate without worrying about their trade secrets being stolen by foreign competitors, especially companies that are developing artificial intelligence models that are so important to our national security. When companies abroad steal detailed information about American firms and their innovation and the software, model weights, chips to develop their own technology, it makes it easier to surpass us in the global race to develop AI and so many other innovations. We also know that in many cases, foreign theft of these trade secrets can pose national security risks if those secrets land in the hands of foreign governments. And I know our witnesses will speak to these themes and more. So thank you again for joining us. Thank you, Mr. Chairman, and very excited about the work ahead.
Thank you, Senator Schiff. Introduce the panel. Mr. Boris is Executive Vice President of Product Development for Fortune Brands Innovations. Mr. Boris has been in the company since 2009 and oversees its product development engine with responsibility spanning innovation, engineering, project management, technical strategy, and process management. Mr. Cohen serves as Senior Technology Fellow at the Asia Society of Northern California and the Asia Society Policy Institute located in Washington, D.C. Mr. Cohen previously served as the first USPTO representative in China and as USPTO Senior Counsel. In total, Mark has 40 years of private, public sector, in-house, and academic experience in China. Mr. Muller, a neighbor of mine, serves as Vice President of Corporate Communications for Charlotte Pipe and Foundry Company, which was founded in 1909. Mr. Muller heads Corporate Communications and Government Affairs for Charlotte Pipe, and it's a fifth-generation family. Owned and manufactured, based in North Carolina. Their story, I hope that you have time to tell, but you want to talk about rampant theft in China. They have a very long story to tell, and it's time to end it. I don't want to see a sequel, Mr. Muller, so I'm looking forward to your testimony. Ms. Temple is Senior Executive Vice President and Global General Counsel for Motion Picture Association, where she oversees all of the association's legal affairs and content protection efforts around the world. Prior to joining the Motion Picture Association, Ms. Temple served more than 8 years in the U.S. Copyright Office, most recently as the Register of Copyrights. Welcome. Mr. Boris, we'll start with you with your opening statement.
Chairman Tillis, Ranking Member Schiff, and distinguished members of the committee, thank you. I'm an engineer by training with 25 years of experience in product development and supply chain, 16 of those at Moen. I'm honored to be here today on behalf of Fortune Brands Innovations' nearly 10,000 associates, including nearly 2,000 team members from North Carolina. I would like to call to the committee's attention how intellectual property violations are leading to serious health risks for tens of millions of Americans. In 1937, Al Moen burnt his hands, an accident that inspired the invention of the single-handle faucet. That American ingenuity launched Moen, now the #1 selling and most trusted brand in America. Moen flows approximately 1.5 trillion gallons of water through our products annually. I'm here today with an urgent warning. American health and safety is at risk, and no one knows it. An alarming number of low-cost, unrecognized imports, a significant majority of them from China, are flooding America. We estimate 35 million off-brand units have been sold to Americans over the last 5 years. Despite legislative advances like the Informed Consumers Act, the challenges are accelerating. In fact, we expect the wave of counterfeits to swell further as they leverage AI technology. Their tactics misuse IP rights to deceive consumers into buying their goods that most concerningly place harmful products into American homes. We enlisted IAPMO, the recognized leader in plumbing fixture testing, to independently evaluate the top-selling off-brand faucets. We found grave concerns. When people think about safe drinking water, they think of their municipal water supply. But the last thing that touches consumer water before they fill their glass is generally a faucet. Safety standards exist to ensure these products do not put toxins into drinking water. IAPMO independently tested the top 19 selling off-brand faucets to these standards. The results are alarming and, frankly, unacceptable. 90% failed the drinking water standard. Nearly 60% exceeded lead limits, one surpassing 500% for lead. And nearly 80% failed for chemicals linked to liver damage, or even chemicals used in lice and scabies treatments, with one almost 600% over standard. If this sounds alarming to you, it should. In addition to drinking water safety, bath safety is also of concern. Moen's best-selling valve is a device designed to aerospace level tolerances and assembled under strict quality controls in North Carolina. We estimate 45 million units have been sold in the last 20 years. A product, because of its sheer scale, is facing a rising tide from counterfeiters. IAPMO tested 6 leading off-brand faucets. All 6 failed safety standards, one by 750%. These products risk scalding consumers and exposing them to dangerous temperature swings, exact issues the standards are meant to prevent. When searching for this one Moen valve on e-commerce, we found one real Moen SKU. That same search resulted in 41 counterfeit SKUs. Consumers have no chance of discerning a real product from a fake, nor do the most experienced plumbers. This goes beyond individual homes. Substandard products can threaten municipal systems and even national infrastructure. They undermine innovation, consumer confidence, and put American economic leadership at risk. With this committee's leadership, our asks are for further refinement of the Inform Act, seeking to close loopholes these cheaply made foreign bad actors continually exploit, including their whack-a-mole brand approach. Encourage consistent verification protocols to certification for national safety standards, and strengthen IP enforcement by closing loopholes that allow counterfeiters to operate just outside the law while intentionally confusing buyers. We are working with IAPMO and our industry associations. We have shared this data with the Consumer Protection Safety Commission, and they've been very engaged and, in fact, issued warnings this morning about some of these products. This is about preserving the system that enabled Al Moen's innovation and protecting your constituents today. In closing, one of these cheap brands markets itself as providing healthier drinks. Their ad features an expectant mother drinking water from a faucet. That faucet tested at 591% over the legal limit for a probable carcinogen. That faucet is cited to have sold over 2,000 units last month alone. This is a moral imperative. Thank you for your time. I look forward to your questions.
Thank you, Mr. Cohen.
Thank you, senators, staff, and friends. Thank you for this opportunity. Further to my personal observations and my written testimony, I would like to discuss or focus here on the future of our IP-related engagement with China. I believe that in the past, we naively assumed that the WTO would lead China to democracy and free markets. President Clinton said that the WTO will move China faster and further in the direction of democracy and free markets. President Bush repeated this, that trade with China will promote economic freedom and that a measure of political freedom will follow. Others, like former U.S. Trade Representative Barshevsky, argued that the U.S. failed to enforce China's commitments and therefore the desired reforms, economic or political, were thereby forfeited. There was a contrary perspective, however, which we do not hear about, and that is simply that autocracies will embrace whatever enhances their power, including IP. The Soviet Union was for decades one of the 10 largest patent offices in the world. North Korea, like the United States, has a patent clause in its constitution, Article 74. It was, in fact, the Hong Kong delegation negotiating the WTO agreements that inserted into the TRIPS agreement that IP is a private right, and one can imagine what they had on their mind. China's rise was in many respects predictable and observable through patents, scientific publications, talent flow, education, investments, trade data, and other sources. And in general, we chose to ignore them. We need to bring back that capacity to better understand China's science and technology trajectories and the challenges it brings. And we need to bring that back into Congress, which formerly had the Office of Technology Assessment, and to the U.S. government generally. An illustrative case of this, of the U.S. inability to foresee future challenges, was a matter that first began about 17 years ago. At that time, China was placing unfair conditions on technology transfer to China. The conditions were imposed on foreigners. That case was rejected twice during the time I was working in the Obama administration. The first Trump administration won the case at the WTO. They accepted it, and within a year, the relevant law was changed. And it was ironically Donald Trump, who was probably most opposed to the WTO in its current form, who led that case forward. In concrete terms, here is what we need to do. One, we need to revamp how we engage in China on IP, science, and technology. We need depth and continuity. At high-level negotiations, there are typically no IP experts in the room. We need a deputy director for international affairs at the USPTO as a counterpart in U.S. negotiations. To be clear, I do not mean that the U.S. should engage in negotiations merely for the sake of negotiating. In Geneva recently, both sides agreed to establish a mechanism to continue discussions about economic and trade relations. My experience is that only if a dialogue is run by someone with experience and depth is it possible to resolve IP-related issues. Two, we need to focus on IP as a private right, for which we also have to have industry in the room. IP is not something that is limited to what the government administers through bilateral negotiations. Typically, U.S. negotiators know best what they are doing for the government: criminal enforcement, customs matters, antitrust policy, etc. And these are important. But we also need to address core issues such as civil enforcement, the lack of transparency of the courts, track 2 negotiations to encourage industry to engage with its counterparts. And I believe also that the U.S. should consider developing a comprehensive inventory of China's statist approaches to IP and its impact on the U.S. system as a guide to evaluating our next steps. 3, we need to improve our government structure so that it is accompanied by comprehensive self-strengthening to address weaknesses in our system. In this respect, I commend this subcommittee's efforts to propose new legislation. We need to address domestic issues such as unstable patent eligibility standards, which in many cases are weaker than China, and the declining availability of injunctive relief, which is also weaker than China. We need to engage with China as well on a fair and reciprocal use of each other's systems, such as through our patent prosecution highway and other bilateral arrangements. We also need to understand and anticipate the asymmetric challenges that China poses, of the type that some of the witnesses today are talking about. Our agreements with China on all technological and IP-related issues should be leading edge and thereby help set models for the world to better protect and monitor IP rights and use IP as a platform for collaboration. In closing, I also believe that we can, in fact, learn some things from China, such as in public access to the IP system, its availability to smaller companies, and the stability and non-retroactivity of China's IP laws. Ignorance of a competitor rarely has long-term rewards. At the same time, we need to do things smartly in accordance with our strengths, free markets, and rule of law. If so, I am certain we can succeed. Thank you for your time and attention.
Thank you. Mr. Muller.
Thank you, Senator Tillis, and members of the committee for the opportunity to tell our story. Senator, you're familiar with it, but it's an honor to be able to bring it to the attention of the subcommittee. Charlotte Pipe and Foundry is the nation's largest maker of cast iron and plastic pipe and fittings for plumbing systems. We are a 5th-generation family-owned business, and we've been in continuous operation in the United States for 124 years. We employ 1,800 associates in 8 plants across the country. In 2017, Charlotte Pipe discovered, only by accident, that a company called Yitai Plastic Company Limited from Shanghai had been producing, marketing, and selling plastic pipe and fittings in China and several Asian countries under the Charlotte Pipe name for years. Unbeknownst to us, Yitai Plastics had registered the Charlotte Pipe name, brand, and logo in China in 2010. Yitai is in the business of manufacturing and supplying goods such as plastic valves, fittings, and industrial piping systems for both domestic and international markets, according to their trademark filing. Charlotte Pipe has spent hundreds of thousands of dollars to retain a law firm in China to attempt to recover our intellectual property. As you might expect, our experience in enforcing our IP rights in China have so far been unsuccessful. In a 2018 ruling, the Trademark Review and Adjudication Board in Beijing sustained the registration of the disputed Charlotte trademarks. In issuing its ruling, the board claimed the evidence we submitted was, quote, insufficient to prove the use of the disputed trademarks would create confusion among consumers, end quote. However, in my submitted testimony and from this trade article, you can see how this logo prominently displayed on a building in Shanghai would lead any reasonable person with a strong impression that Charlotte Pipe was operating in China. The Beijing Intellectual Property Court also ruled in Yitai's favor. We filed an appeal to the Beijing High People's Court, and our local Chinese counsel attended a pretrial meeting on January 11th, 2023. After the hearing, the judge informed the parties that the cases were, quote, complicated and needed to be discussed again by the collegiate bench of judges, end quote. We are still waiting for the results of those conversations. In other words, the case has gone cold. This is not theft of tech or trade secrets, but something as public and as one of the strongest and most recognizable brands in the plumbing industry that has been in use around the world for generations. Charlotte Pipe owns and has been operating under the name for almost 125 years. The logo on the business card and on the side of the building was created in the 1960s. Our Chinese counsel confirms Yitai is still operating and using our brand. In my submitted testimony, you can see a screenshot from a Chinese search engine that was taken just last week, and they are still operating under our IP. From our experience, it is clear that China lacks the rule of law and the political will to hold Chinese companies accountable for blatant IP theft. According to the House Select Committee on the Chinese Communist Party, Chinese intellectual property theft is estimated to cost U.S. taxpayers $600 billion a year. We are just one company making simple plumbing products, yet we have been under attack by China for years, from stealing our brand to dumping inferior quality products to evading lawful anti-dumping and countervailing duties. This economic aggression against Charlotte Pipe has gone unpunished by the U.S. government. Over the course of the last 7 years, we have spent millions of dollars to avail ourselves of every legal remedy to stop the fraud, the dumping, the illegal subsidies, the transshipment, to no avail. The illegal trade flows continue, and Chinese producers who aim to take our jobs go unpunished. To address the rampant cheating, Subcommittee Chairman Tillis last year introduced the Fighting Trade Cheats Act to strengthen enforcement against this form of trade fraud on the AD/CVD duties. Short of the provisions in this bicameral bipartisan bill to fight trade crime, industries will no longer undertake AD/CVD cases. The cost to file and win these cases is exceedingly high, and the promise of relief has become non-existent in the face of lax enforcement. I'd like to thank Chairman Tillis and the committee for the opportunity to tell this story today, and I look forward to your questions.
Thank you. Ms. Temple.
Thank you, Chairman Tillis, Ranking Member Schiff, and members of the subcommittee for the opportunity to testify today about foreign threats to American innovation and economic leadership. The American motion picture, television, and streaming industry is a global powerhouse that generates $22.6 billion in exports and a remarkable $15.3 billion trade surplus. We are proud to distribute content in every corner of the world. We are also job creators. As of 2023, MPA member companies in our industry supported 2.3 million American jobs and $229 billion in total wages in the United States. Many of these jobs are skilled labor positions that support middle-class workers and do not require a 4-year degree. Our domestic production activities also support a nationwide network of thousands of small businesses representing every state in the country, and 92% of these businesses employ fewer than 10 people. Yet this American prosperity is put at risk by continued foreign theft of intellectual property on a truly massive scale, often coming from countries such as China, Russia, and Vietnam. Consider that in 2019, U.S.-produced movies and television shows were illegally downloaded or streamed more than 150 billion times. In 2022, there were an estimated 191.8 billion visits to movie and TV piracy sites. That's equivalent to every adult in the United States visiting an illegal site twice a day, every day. In many cases, we have more traffic going to pirate sites than legitimate sites. The theft of this content and related lost revenue severely undermines America's film industry and the local economies it supports. When MPA member companies produce film and television content in local communities in North Carolina, California, Delaware, Illinois, or Tennessee, they invest millions in the local community, including local jobs like caterers, painters, carpenters, florists, and more. Foreign IP piracy threatens these jobs. Already, piracy has cost our economy $29.2 billion in lost revenue and over 230,000 jobs annually. MPA, through our Alliance for Creativity and Entertainment content protection arm, will attack piracy wherever it may occur and uses every possible avenue to shut illegal piracy sites down. But it can take years. All the while, piracy operators are preying on American consumers and illegally profiting on the backs of American creators. These sites often may look legitimate, but are populated by stolen IP with current blockbusters and hit shows. They feature movies still in theaters or not even released yet. They are run not by individual teens in someone's basement, but by sophisticated foreign criminal organizations who are involved in the most heinous criminal behavior you can imagine. And they are specifically designed to target American citizens, your constituents, for their personal and financial data and to expose them to malware and identity theft. Why do these criminals so often target Americans? Because we are leading consumers of copyrighted content and represent lucrative victims. And unfortunately, here at home in America, we have left our citizens and our valuable IP more accessible to criminals. This is not the case around the world. Foreign countries, including leading democracies such as Canada, the United Kingdom, Australia, and Germany, have enacted site blocking to prevent access to illegal piracy sites. Now, more than 55 countries have followed suit. Site blocking regimes are proven to turn members of the public from unwitting victims to consumers of legitimate content services. When you block a piracy site, traffic to that site plummets, and traffic to legitimate sites rises. But of course, this is not news to you, and I want to thank Senators Tillis and Coons for your years of attention to this issue, and note the similar efforts on the House side with IP Subcommittee Chairman Issa and Representative Lofgren. The MPA stands ready to work with you and all stakeholders to enact judicial site blocking this session. It's time, finally, to get this legislation over the finish line. In closing, I want to also acknowledge the importance of keeping America competitive in new technologies of all types, including artificial intelligence. But that doesn't mean weakening strong IP laws and undermining the creative economy. Respect for copyrighted works and other intellectual property must remain a central pillar of our nation's policies, both in how we facilitate innovation domestically and how we address the global race for AI leadership among countries around the world. Simply put, there should be no blanket AI exception to our copyright laws. And in formulating AI policy, Congress and the administration should aim both to advance America's global leadership in AI technology, innovation, as well as maintain the preeminent position of the American entertainment industry. Thank you for your time and attention, and I'm happy to answer any questions.
Thank you all. Before I go to Senator Moody, I'm going to be here for the duration, so thank you for coming. We're going to go to you. Incidentally, I use the chairman's prerogative not to swear you in. I'm assuming you're not going to lie about IP subject. So, Senator Moody.
Thank you, Mr. Chairman, and thank you for highlighting this important issue and calling this hearing. And for those of you that took the time away from your family and your jobs to come here and testify in an informed way, the only way we can have an effect on good policy and approach to issues is to have people that are living it daily come here and be a part of the discussion. So I appreciate you being here today. I'm hearing a lot about theft, and of course, the theft, especially from the CCP. And I think it's so important that we talk about, and again, I know this hearing pertains to foreign threats in general, but I want to talk specifically about intellectual property theft by the Chinese Communist Party. And I think it's important that we're clear about that because the Chinese people in general, I don't believe, want to wake up every day and want to steal from America or Americans or undercut our innovation or do us harm. The CCP might be a different story. And I appreciate you being here to share your examples. I know one of you mentioned the theft by China as it relates to RRP is $600 billion a year. Just that number alone should shock all of us in terms of what it's costing the American taxpayers. But one of the threats I think that we're struggling with as a nation is we are facing imitation threats by the CCP, and we now have companies that are having to go to China courts to try and seek redress. That's just unbelievable. But maybe even more problematic is if they start competing with us or overtaking America in innovation. And it has recently come to light. Last week, a study was released at a major university by anonymous sources that students here on visas from China are being directed to steal and collect information for the CCP. And the reason I bring that up, I think it's related to this hearing today, is because it wasn't that long ago that China passed laws that required its citizens to participate in intelligence gathering and in their national security efforts. And if they do not, as directed, they face penalties. Those laws are on their books. That was not that long ago that they passed those laws. And leading into the last administration, there was a report released showing we are now starting to see organized efforts where they're applying for student visas and other worker visas with the intent to come here and collect information. And the CCP is now directing students. We had a report. We've seen arrests at our universities, on our military bases, of those here on visas. 300,000 a year Chinese students come here under legal obligation to assist with the CCP with intelligence gathering. Not something we're making up. It's not some conspiracy we're trying to push. It's black and white in their laws. And we are inviting them in. I mean, used to be the U.S. was pretty serious about cracking down on espionage. And now we have to have Senate hearings to talk to our corporate heads about $600 billion a year that we're losing in IP losses. And we know that they're here right now because we just had another study released last week saying they're here on our college campuses. Like, arrests weren't enough on our military bases and our universities. Arrests weren't enough, as we caught them with drones, taking pictures, stealing information. Now we've had the actual students here admitting that they are being directed by the CCP. So I don't know when enough is enough to get the attention of the American citizens and certainly Congress that spies are here, they're collecting information, and we've got to be better in America to protect not only our businesses from theft of their property and imitation, but also the theft of what could be really important innovation. We know DOJ just filed charges on someone that was stealing sensitive AI technology from Google. That's going to benefit China in the AI race. We know there was one gentleman arrested in the 2010s and 10s. He was studying at Duke University where he accessed important research, stole it, went back to China, and then became a billionaire. So I want to say, again, thank you, Chairman Tillis. This is incredibly important, especially in light of the more recent developments where we're finding reports that students are coming out and saying, yes, I am being instructed to report back. My family's being called in back in China. And if I may, Mr. Borres, as we go back to imitation and the theft of products by China, money is one thing, $600 billion a year. That's incredible. We should never accept that. Is there a challenge regarding these products not living up to safety standards or presenting consumer risks to those that are purchasing these imitation products?
Thank you for the question. And the answer is absolutely. With the testing that we uncovered both on the drinking water safety side, where we see people counterfeiting our agencies, like our safety standards, that they're meeting those and putting them on the products. And then the two examples I brought here in front of you, direct counterfeit IP frauds that can scald and shower shock people. So we've seen direct examples in our industry, and I'm certain in many other industries, where that imitation threat is absolutely happening. The other thing I would outline is this whole works with or replaces, and we see that a ton with our Moen products, and it's fooling consumers and really exposing them to those safety risks that I just outlined.
Thank you, Mr. Chairman.
Thank you. Senator Durbin.
Thank you, Senator Tillis. Ms. Temple, you can help me understand something. You formerly led the U.S. Copyright Office. It's rare that the Copyright Office is in the news, but it has been over the last several weeks. And after the Librarian of Congress was dismissed by this administration, there were dismissals as well in the Copyright Office. And when asked why people were being fired from that office, someone suggested it was because of a report involving AI and the copyright laws. Are you familiar with that?
Yes, I am familiar with the report.
Can you tell me what was the controversy in the report?
I don't think that there was a controversy in the court, quite frankly. It was a comprehensive, clear report that you would expect from the talented and expert folks in the Copyright Office. It was explaining issues with respect to fair use and AI. It didn't pick sides. It actually just talked about the fact that in assessing whether AI platforms are fair use or not, are engaging in infringement or not, context matters. And it also noted, as I mentioned earlier, that there is no blanket AI exception to our copyright laws, and that our copyright laws are fit for purpose and can be applied to these type of new AI platforms.
How would you explain to a person in the street why AI and the development of AI has any relevance to the film industry?
Well, it has relevance, I think, to everyone in the world, but it has particular relevance to creators on both sides. So both AI can use the works of creators and artists in its training, and that was the focus of the Copyright Office report on this issue. And AI can be a tool for filmmakers and others in order to create more works.
Mr. Muller, your testimony about the experience of your company sounds familiar. I think I've heard stories like this before. I recall meeting an inventor who had invented a lawn toy that attached to a hose, and it turned out the Chinese stole his idea that had been patented, and he had to literally fight for years and risk everything, every penny he had on earth, to successfully defend his patent in that circumstance. How much have you spent on lawyers and fighting this China battle?
Over $100,000 to retain a law firm in China, and there was no guarantee of success. So that money is gone. Through defending ourselves on AD and CVD challenges, cases, filing EPA enforcement actions through the Customs Department. This IP theft, we've probably spent over $6 million trying to defend ourselves from attacks by China. And we're just one company. Spread that across industries, across our economy, and it's, again, $600 billion or probably more. U.S. companies are trying to spend to defend themselves.
So we're now at the negotiating table with the Chinese, trying to determine whether there'll be a tariff, and if so, how big it will be. Do you know if this issue of intellectual property is on the table?
It should be. If it's not, it should be, Senator. And across the board, there's other issues too that the tariffs, frankly, in our view, the tariffs can't be high enough.
Well, certainly with your experience, I can understand that conclusion.
Yeah.
I just say that tariffs, of course, are a tax that will be paid by consumers ultimately in the United States. And the question is, what will we get from paying that tax? And if we don't at least guarantee that we protect the property rights of our own American citizens and companies, I think we've fallen short of the mark.
Yeah. Well, I thank you for your question. And we have been in contact with the Office of Management and Budget. They're familiar with our case. And hopefully that will be included in their negotiations. And also at USTR, we have filed comments on various countries with USTR. So we have gotten the word out.
Thank you. Thank you, Mr. Chairman.
And Senator Durbin, the bill that Mr. Muller alluded to in his opening statements is something that we put out last year. It's called Ending Trade Cheats, and basically it's giving the private sector a private right of action to become more of a force multiplier on all these. There's so many complaints coming into customs that they can't process all of them. What we're trying to do is give the private sector a vehicle, a pathway for being able to do it so that China doesn't continue to flood the zone. What they're doing is they're just flooding the zone, making it very difficult for enforcement actions to go through just through sheer numbers. So I hope you'll take a look at that bill. We'd like to get it done this year. My question, and actually I want to go back to Mr. Muller, to give y'all an idea of just how egregious this situation is. The company that they're talking about in China has almost like a movie set reproduction of Charlotte Pipe's operations in downtown Charlotte. That is how egregious they are. And then they are stamping a Charlotte Pipe brand on a pipe and exporting it. I mean, this is just how shameless, in plain sight of the Chinese government, how anybody could spend hundreds of thousands of dollars in a lawsuit in a country that respects the rule of law and not prevail demonstrates just how much work we have to do to get to a fair trading relationship with the Chinese Communist Party now. And I share Senator Moody's position. It's not a fight with the Chinese people. It's the leaders of a country who are building some of their success on the backs of American innovation. Mr. Boris, you mentioned that I think the faucet that was advertised were 2,000 units sold last month alone in the United States. So would you give me that statistic again of just how much in your testing unsafe substances were in that particular faucet?
Yeah, thank you for the question. That faucet was one of the top 19 sellers that we identified through third-party data. We worked with IAPMO to independently have that faucet evaluated. That faucet came back failing drinking water standards with the one chemical I mentioned that is a safety standard for us. It failed at 591% of the legal standard.
And do we have a way of knowing who has those faucets?
Unfortunately, no.
Were they sold through big box retailers online or combination thereof? How did they get into this country and into homes?
I would say that the vast majority or mostly are all sold through e-commerce platforms.
Okay. Mr. Cohen, try to explain, people, I'm not an IP expert. I got involved in IP when we decided we had a problem here. I'm a business person. IP was a problem. That's how I got involved in IP. How would you or any of you describe why the average American should be concerned with this? How does this IP theft issue affect just the average citizen that's going to work every day and living their lives? How would you describe it, Mr. Cohen?
It's a great question, and actually, I think we could do a better job in this country of getting people to understand what the IP system does. I think we all know here that it's in our Constitution, it's in our foundational documents and how we've evolved as a country, that it rewards inventors, and we have our Thomas Edison and Edwin Land and other people in the back of our mind that we want to support. And that it protects brands, and to a degree, to a not insignificant degree, it protects consumers who rely on those brands. And in addition, it protects creation. And we are all creators in some way, whether it's our letters to family or notes or memoirs or something we might paint as a kid. And that's what copyright does. So it really steps into the void of stopping someone from illegally, willfully, perhaps criminally misappropriating something that you have created or invested in.
And Mr. Muller, what is the level of competition? How much of the market for Charlotte pipe product do you think is being satisfied by these thieves and global demand? Do you have any rough idea of how much of their products being sold globally?
It's hard to have visibility into the Chinese market, Senator. We know that we've done a fraction of business in China and really even in Asia. So our guess is that Yitai and others that are engaged in this activity have the lion's share of the Asian market. And to answer your question about
of China and the Asian market, yeah. Because you would think the Charlotte Pipe brand would be a brand that, particularly in the broader Asian market, is a brand that's known. I mean, you're a world leader there. In China, I guess you could go either way, whether or not the Charlotte Pipe brand would matter to the Chinese government. They can tell people what pipes to put in whatever buildings they're building there. But I think it'd be interesting if we can get any more information about the revenue theft there.
Yeah.
It would be helpful if we could get some feedback from that. The same for you, Mr. Boris.
Well, in Singapore, Senator, in their filing, Yitai did say they did $364,000 in revenue in Singapore in 1 year, the year they filed our trademark. So that's a significant.
And what's the current status of the case in the Chinese courts?
It's on appeal, and we have not heard back from the Chinese court. And we were.
So the court ruled in your favor?
No, they ruled in the adjudication board ruled in the Chinese favor. We appealed to the Beijing People's High Court. That's where the appeal sits unresolved.
What kind of a kangaroo court would look at the facts of that case and rule that way? Oh, I'm sorry, I poisoned the well with the answer in it.
That's a leading question, Senator. But we did also challenge it in Singapore. Yitai filed in Singapore, and we were successful. Initially, we were unsuccessful, but on appeal, we did recover our brand identity in Singapore. So they are not allowed to go to market. So the facts of the case are there. We have the winning facts. But to your question, why the Chinese Beijing People's High Court won't see it our way?
Because Beijing told them so. Senator Schiff.
Thank you, Mr. Chairman. And Senator Coons, we were bragging about you while you were out of the committee, and we will not repeat ourselves. But thank you for your amazing leadership on this subcommittee. Mr. Cohen, I wanted to get your sense, because I've heard conflicting opinions about the role that piracy played or didn't play in the Chinese creation of DeepSeek. Do you have a view of whether this was their own innovation or their own, to use a term of art improperly in this context, fair use of the outputs of American AI models?
Yeah, I've seen some articles, and I haven't really gone into it at great depth. Obviously, I think it would offend any notion of fair use that we could conceivably imagine. But beyond that, I'm happy to respond in in writing to this.
Yeah, in this case, if you've tracked of a former Google software engineer who was charged by DOJ with economic espionage, are you familiar with that case?
Somewhat.
Someone who left Google, took a lot of the information with him, became a founder and CEO of a technology company in China focused on AI. How frequent is that kind of occurrence? That's pretty blatant, right, compared to cyber theft and other means of acquiring, stealing trade secrets.
Well, that's a great question. Let me respond first by saying that trade secrets are the most poorly enforced right of any IP right in China. And that's according to Chinese statistics. So you have historically about a 30% chance of success on a trade secret claim, compared to as high as 80% official data. We can quibble with that, but for a patent case, it's about 80%. So you're starting from a very low threshold. The way to protect trade secrets in China in general is through non-compete agreements. And some states, including California, make it very difficult to enforce their non-compete agreements in other jurisdictions, particularly outside of the United States. I have no problem internally within the U.S. if some states want to enforce non-competes or enforce them. We have full faith and credit. We have discovery. We have a legal system that works pretty well in most states. But when it comes to other jurisdictions like China or other places where there's rampant trade secret theft, the inability to enforce a non-compete agreement can really cripple a company's ability to stop the theft of trade secrets. And we've seen this repeated over and over in many high-tech, with regard to many high-tech companies. In fact, in California, you could be originally employed at a competitor. Let's say you're at Microsoft. You get hired by a California company. You're sent to their Beijing office, and now you're free of the Microsoft non-compete agreement because of the historically great interest that the state of California has in not enforcing non-compete agreements generally. So this is an issue that I can understand that for California's purposes, this is how California envisages its labor market. But when it goes overseas and starts affecting American competitiveness, we also have to think of its consequences more generally.
Well, thank you. I appreciate that. Ms. Temple, I wanted to ask you about IP. And the U.S. is behind many other countries in terms of combating pirated content, much of which comes through foreign entities impacting American rights holders. Some of the EU member states have adopted or voiced support for a no-fault injunction system for the most blatantly infringing sites. What are the pros and cons of that? Would you advocate we adopt something similar? And what stakeholders in the U.S. might be opposed to that adoption?
Thank you for the question, Senator. As I mentioned in my testimony now, we have more than 55 countries who have adopted no-fault injunctive relief, otherwise known as site blocking. That has now allowed us to have significant experience in how those regimes work. The EU actually has also done studies in terms of how those regimes work and how they can be implemented in both a safe and effective way. And so I think that we have a lot of experience in terms of establishing a site blocking regime here in the United States. Overseas, in fact, those stakeholders who are involved, like the ISPs, are actually partners. A lot of the regimes overseas, we have collaborative partnerships with the ISPs. We're working with them day in and day out in terms of making sure that the systems are implemented properly. So I would be very, very hopeful that the ISPs here in the United States as well would follow their lead and work with us to collaborate on a way to effectively implement site blocking in the United States against these rogue piracy sites.
And have they been thus far in opposition to it, the American ISPs?
I would say that in the past, the American ISPs have been opposed to legislation. I know that you all have been looking at this issue for some time, and again, really thank Senator Tillis and Coons for all of their work on this issue. I think now that we do have a wealth of experience of site blocking regimes throughout the world, and now that we do have those partnerships with other ISPs in other countries, such as in the EU region, I'm hopeful that the ISPs here in the United States will not have the same level of opposition that they've had in the past.
Thank you. I yield back, Mr. Chairman.
Senator Blackburn.
Thank you, Mr. Chairman, and thank you all for being here. As we look at what we're going to do with emerging technologies, having this discussion is so important, and having your input is so important. Mr. Cohen, I want to come to you because if you take the decade 2011 to 2021, there was such a surge in patents that the Chinese were filing, and by 2019, they had produced more patents than we had for the first time in history. And that should be flashing red lights to us. We all know how they reverse engineer, they steal our intellectual property. It is a cost of hundreds of billions of dollars to our nation's economy. And tomorrow, Senator Coons and I are introducing a bill, the Countering Chinese Espionage Reporting Act. And this would require the Department of Justice to submit a report to Congress on exactly what is being done to combat this IP theft that continues to take place. Talk a little bit about looking at this holistically. In addition to legislation, what are steps? What if you could shape this response that our country has to China on this theft, what would you do?
That's a great question, and it really is the kind of question that if I was back in the government, we would have a whiteboard exercise, because there are multiple aspects that you would need to address it. To give you an example of two things you did not cover that are unfair acts, one is that the Chinese government has on its books a rule that requires Chinese students overseas or professionals overseas, if they plan on filing a patent based on something created overseas, to first report it to the Chinese embassy.
How interesting is that?
Another possibility that if you're Chinese, if you fill out the Chinese patent application form, there's a box you can check where you can say, I will file this patent anonymously. Why would you want to file a patent anonymously? There's actually been two criminal trade secret cases in the United States where an anonymous Chinese patent filing appeared in that case, where the Chinese party, or the party that was stealing a trade secret for the benefit of a Chinese entity, requested that his name be disclosed from the Chinese Patent Office filing. So there are actually aspects here that need to be addressed head on that are built into the Chinese legislative system. There are a lot of reasons that China became a mega patent filing destination. Most of them are related to subsidies, and some of them are related to the types of patents you can file in China. For example, my quick test on quality of Chinese patent filing is if you see that the majority of the patents are filed from September to December, it's probably because they want to use up subsidies before the end of the year.
Well, let me bring you back to the USPTO, because right now there is a backlog of 800,000 patents. And Senator Welch and I are working on legislation that would speed these patents on AI, quantum, these emerging technologies. And I would be interested in your take on that, because this is something that deals with our national security.
We have to speed up examination of patents. And we actually have a bit of a problem here, because using the patent prosecution highway, Chinese companies can secure a patent within as little as 2 to 3 months of their filing in China. Whereas a U.S. entity filing in the United States, according to current pendency levels, will probably have to wait over 2 years, perhaps even more than 3 years. So we need to make sure that our system with China and the rest of the world is reciprocal, and that patents that are critical to the United States for its economic development are treated fairly and are expedited. We're currently not doing that.
Okay. Ms. Temple, I'm about out of time, but video piracy. is something that so many of my creators in Nashville pay attention to because it adversely impacts them. And these are individuals that lose just so much money every year. Nationwide, this is billions of dollars in loss. And I know that you all have supported site blocking legislation. And since I'm out of time, if you will just submit to me in writing instead of walking me through, just submit what you think that should look like, how we use watermarks, how we approach this to solve this problem.
Thank you, Senator. I appreciate your focus, and definitely we can submit something for you.
Thank you. Thank you, Mr. Chairman.
By the way, I apologize for the flashing LED. I'm pretty sure it's Chinese counterfeit. Senator Coons.
Thank you, Chairman Tillis, Ranking Member Schiff. It's great to be having this same hearing. 2 years later, we had an identical hearing 2 years ago. And despite the strong bipartisan agreement about the importance of protecting American intellectual property from Chinese theft and infringement, I wish we had seen more progress through the Senate and the House. Foreign websites continue to steal and profit from American copyrighted content. China remains the world leader in the theft of American IP, using what it's stolen to directly infringe the rights of American companies and put American consumers at risk. And our patent system still needs serious reform, or we're going to find ourselves looking up at China as the new global innovation leader. I do, at the opening, though, want to say something about recent developments at the Library of Congress. President Trump fired the Senate-confirmed librarian, someone I've long admired, and then tried to fire the Register of Copyrights, who was appointed by and answers to the librarian, not the president, and who plays a critical role in copyright standards and protections, increasingly urgent in the age of AI, where the question of whether or not copyright will be upheld is at issue. And as the name suggests, it is the Library of Congress, not the Library of the White House. Register Perlmutter is a longtime public servant with deep experience at the PTO and the Copyright Office, and testified before this very subcommittee in November and has been leading that office into the 21st century. I'm encouraged by statements on both sides pushing back on these unlawful moves, but I think it's important that we push back on efforts to intrude on the legislative branch prerogatives. Professor Cohen, if I could, I think, of course, I think that we need to strengthen our IP system to better compete. In your testimony, you highlight the need to enact 3 bipartisan bills: Prevail, Para, Restore. Why is restoring injunctive relief critical to maintaining our global IP leadership, and what's the consequences if we don't?
Yeah, great question. And again, I can respond with the official statistics of China, recognizing that the statistics are problematic, but they're the only statistics we have. The injunction rate in China for an IP dispute, if you've won, is about 98%. This is basically automatically available. Now, if you're going to go after a manufacturer, let's say of the type that some of the other people testifying today are trying to pursue, you're best off if you could get a judgment in your favor where the product is manufactured and get an injunction against it. And in that respect, China offers a competitive advantage when you consider that, again, according to available data,
right,
the time to first instance resolution of the case is 6 months, 3 months on appeal. So within 9 months, you've exhausted your appeal, you have a final injunction, low damages, so you have to calculate that into your strategic planning. That, when you look at global patent litigation, for example, where we have these multiple jurisdictional cases appearing before the Unified Patent Court, the Federal Circuit, the Chinese courts, knowing that an injunction is available as an automatic outcome is a significant advantage to helping to determine not only the national rate, the royalty for that patent, but the global rate.
Could you speak to the importance of having an intellectual property enforcement coordinator to bring together different actions that are spread across disparate entities? It hasn't been filled in several years across two administrations. I think it's a critical role. How would it help us speak with one unified U.S. voice and ensure that enforcement actions are more effective than they currently are?
Yeah, well, IP enforcement, and we've already heard about some of this today, bridges many disciplines, including consumer safety, including pharmaceutical safety, including obviously patents, trademarks, copyrights, and other areas, and including state and local government. California has a very active criminal docket in intellectual property enforcement. New York does as well. In fact, at one time, New York probably had as many cases as the federal government. Most of them were small scale, people selling goods on the street. But the ability to coordinate them nationally, on a state level, and finally internationally, where often the evidence is located overseas, is critical. And that's the reason we need a coordinator.
That's something I hope we'll all be working on a bipartisan basis to press to finally fill this position after a long time. Mr. Muller, Mr. Bors, I worked for 8 years for a global manufacturing company. We had a whole room at our headquarters of fakes that carried the same trademarks and stamps and materials and had been made all over the world, and yet failed to meet the product safety and performance standards that the company I worked for was built on. Mr. Bors, your talk about Moen faucets was a new example to me of a risk to consumers and to product safety. We've made progress fighting counterfeiting with the Inform Act, something Senators Durbin and Cassidy led, but we all co-sponsored. But Senator Tillis and I are continuing to work on a bill entitled called Shop Safe that holds online platforms liable for selling counterfeit products unless they adopt certain best practices. What do you think online platforms like Amazon and eBay could be doing better to stop the flow of dangerous counterfeit products from China to the United States?
Thank you very much for the question, Senator Coons. First, I applaud your guys' work on the Inform Act. It's the right steps, and we're making further steps. With regards to your additional act, I think there are absolutely tools within various e-commerce platform sites to help govern better, making sure products that are for sale, both in my industry as well as many others, meet safety standards and meet national code requirements. It's about ensuring that those platforms all have the liability to enforce those, and the manufacturers who are trying to sell on those platforms are telling the truth when they put that information in.
I think millions of Americans unwittingly buy counterfeit products day in and day out and are largely oblivious to the risk. Senator Grassley and I have long co-chaired the Trademark Caucus, and I think there's a lot more we can and should be doing to protect storied American manufacturers, multi-generation manufacturers like yours. Last question, I know I'm over time, with the tolerance and forbearance of the chair and ranking, if I might, Ms. Temple. Finally feels like we're making some real progress here on site blocking after years. One of the key roadblocks to getting a final deal is whether ISPs should bear liability both for should benefit from immunity, both prospectively and retrospectively. Can you help us understand the difference between these types of what kind of immunity ISPs might be looking for and what you think a path forward on that specific deal point might be?
Yes, thank you, Senator. I would say that, in our experience in the countries that have adopted site blocking, immunity has not been an issue. ISPs have not routinely been sued for enforcing site blocking regimes. So, I think in our experience, we don't think that this is a provision that is necessary at all. But certainly, if the ISPs feel more comfortable having at least a narrow, targeted immunity provision that would protect them from any liability for enforcing or implementing a site block, that might be something that would be appropriate. But again, in our experience, that's not been an issue in the 55 countries that have adopted site blocking regimes.
How important is site blocking to your industry?
It is a critical enforcement tool. Obviously, as I mentioned before, there are billions in dollars that are lost annually to digital piracy. And unfortunately, there are safe havens for these foreign operators where we can't actually go after them and get them, like in China and Vietnam and elsewhere. And the only way that we can effectively enforce our rights is by basically cutting off their customers. And that is making sure that they are not able to get these unwitting victims from the United States to buy their, or purchase their services. And so site blocking is a critical tool that we use in all of the countries that we are able to do so.
Well, thank you. Thank you all for your testimony, and to the chair and ranking, thank you so much. I look forward to working with both of you on these bills.
Thank you, Senator Coons. Mr. Cohen, you mentioned patent eligibility as part of your opening statement, and sure you're aware of the para bill that my office and Senator Coons and others are working on. Give me your perspective on your read on the bill. What are its strengths? What are the areas that we need to focus on?
Well, I think patent eligibility has been a problem since about 2012 in this country, and it's become a problem both because of declining scope of eligibility and instability and unpredictability of judicially made doctrines that were probably unnecessary at the outset. And I also believe it's been affecting many leading edge technologies such as medical diagnostics, biotechnology, personalized medicine, AI, telecommunications, blockchain, and narrowing non-eligibility criteria, I think, is in the interest of the United States in order to promote innovation and also to make our patents more commercializable, marketable, and more capable of receiving investment so that folks can go forward and make something from them. We've seen in some academic literature, there aren't many articles, but there are a few, where patents were denied in the United States but granted in other jurisdictions, typically the European Union or China. There was one study that had about 18,000 patent applications, of which 1,600 were granted by EPO or China, whereas USPTO had denied all of them. So this is a problem which has caused demonstrable losses. One study calculated a $9.3 billion loss in investment owing to patent ineligibility doctrine. And I think basically that the pathway of para is the correct one, which is narrowing the scope of ineligibility rules so that there's greater confidence in the outcome of examination from the PTO. There are problems outside of eligibility that also need to be addressed, perhaps if the legislation goes forward. Inconsistency of examination practices has also been identified as a problem, and I guess it's multiplied when you have unclear judicial rules. And there have been problems with prosecution times as well in the U.S. where there are patent ineligibility issues. I think these can probably be taken care of administratively, but they are also appropriate areas for congressional oversight.
Thank you all. Senator Schiff, do you have any?
I just had one follow-up question to the questions you asked of Mr. Bors and as well Senator Coons. You've got a great brand, and I wanted to ask you about some of the online retailers. Do people buy pirated versions of your product on Amazon? And if they do, are they buying it directly, or is it third-party sellers on Amazon, or is it mostly other lesser-known platforms that are selling the pirated goods?
It's across multiple e-commerce platforms, right? But I think all of us would admit and use Amazon, right? I know my home would cease to function if I didn't, so that's probably the primary. I do not believe consumers knowingly purchase counterfeit. I've worked with Moen and on the Moen business for 16 years. I go on these e-commerce platforms and search for valves I know and products I know very well, and I'm confused as to which ones are the right ones to buy and who are the legitimate ones.
Yeah, no, I'm sure you're right. I think customers would want to buy the real thing. But do you think, does Amazon do any due diligence, not to test the parts necessarily, but to verify that if they're putting a Moen product on their platform, that it is in fact coming from you and not coming from some pirate source? Is there any due diligence that they do you know?
Not that I'm aware of, Senator.
I mean, I assume you've raised this with Amazon, and not just Amazon, but the other platforms. What do they say? It's not their responsibility, or, I would presume that when they're selling something directly, as opposed to being used for a third party to advertise or sell their products, they're the buyer and they would know who they're buying from. And I don't mean to necessarily single them out, but how much premeditation is involved in putting products on that? Is it we're not going to bother to ask the question because we don't want to know the answer?
I would have to ask them that question. I know when we got the data, the first place Moen went, was to our customers. So we took this to Amazon and Wayfair and Home Depot, all of our big partners in this, and they have acted. Lots of the SKUs have been taken down off of the e-commerce site. I think part of the issue that we continually see is this whack-a-mole that I described in my testimony. So they're taken down, and then 3 weeks later, they come back up underneath another brand with thousands of fake generated reviews, right, with different marketing techniques to try to sell more. And unfortunately, we're spending as much time fighting these fake and counterfeit products that don't meet safety standards when we should be, spending that time innovating and growing the American economy.
Well, thank you very much. Thank you, Chairman.
Well, thank you all for being here today. This is a hearing similar to the one we had in the last Congress. We've made a little bit of progress, but not near enough. The safety concerns here, the Shop Safe Act that Senator Schiff, we should speak with you about, that Senator Coons and I have been working on, are all just sort of bricks in a foundation that we have a lot more work to do. I'm gonna keep, for those of you, Mr. Muller and others, some of the information that you all presented here, some additional substantiation beyond your opening statements. If you can get it to my office, we will keep the record open until next Monday. If you want to provide additional information to our office, I think it would be helpful for the record. And a continued dialogue. We have to make it clear there are a variety of reasons. We've talked about the theft and the economic loss to the United States, but we're talking about loss of life here too. And so this is a very serious subject that I anticipate this Congress to be every bit as productive as the last one, to make a few more steps. Ms. Temple, I didn't get a chance to ask you questions, but I think you know that we're continuing to bear down on felony streaming and making sure our creative community is also covered. So thank you all and Mr. Cohen, we're probably going to submit a bunch of technical questions for you. So we look forward to your response and you continuing to share your expertise with the committee. So thank you all for being here today. And we appreciate your participation, and we look forward to the continued dialogue. Committee's adjourned.